here. So as you can see, ladies and gentlemen, Jan van Riebeeck has joined me on the show.
I find that very offensive. I prefer it if you refer to me as Captain Jesus van Riebeeck.
Yeah, man, I saw some of the comments on the stream, Afriforum stream of the case, and some people were like, "Oh, Jesus is defending Afriforum," which was entertaining to say the least. But yeah, ladies and gentlemen, Mark Oppenheimer joining me once again on the show. Mark, thank you so much. How are you doing?
Yeah, absolute pleasure. I mean, it's been a very busy 2 weeks, as I'm sure your viewers know. So I'll just say this, and you might just get everyone log off. But the bar rules prohibit me from talking about litigation, which I'm currently involved. So I can't talk about the case at all. We can talk in general terms about free speech, hate speech. If you want to ask a bit about the art of trials, what's involved in cross-examination and things like that, that I'm entitled to talk about. But we'll have to wait until judgment and until the appeal period is finalized before I can talk about the case.
Yeah. So, can you answer this one? When do you think judgment will be made?
No.
Okay.
I can give you an indication of how it works. So basically, the way trials work is that you start off with your evidence. So that's gathered through a kind of examination in chief process. So I ask my witnesses questions; they're then cross-examined. And once the evidence is all finished, you then have a trial transcript. So it's 9 days of evidence, so it'll be in excess of 1,000 pages. I'll then draft up heads of argument. And the other side will do heads of argument as well. We'll have a separate day for arguments in court, which will probably be publicly available, so people can sort of see that. And the purpose is really to synthesize the evidence and the law. So, a lot of people said to me, "Oh, what's the result?" People sort of assume you kind of get to an outcome straight away at the end of a trial, but you don't, because there's an enormous amount of evidence. And so I'm, talking generally about how trials work. You then take the evidence and you apply it to the law, and you come up with an argument for, A or B, what the position ought to be. The judge has got to consider that and then produce a judgment. There is a general principle that judgment should be made available within 3 months, but there are reasons apart from it.
All right. That's okay. So it's a bit of a long process, as it tends to be. I think a lot of people don't realize how long the courts can take. I saw some people were frustrated with you against Julius, and yeah, I said on the show, like, because they probably want you to be immediately like, "Your Honor, this man needs to be condemned immediately." It just doesn't work that way. So yeah, I think let me just go to some of the comments here that are coming in. Melanie saying, "Yep, Jan and Jesus." JC McFarlane saying, "Captain Morgan." The Holy Man from Helen. Zoot saying, "Let's talk about impartial witnesses." That might not be a bad topic to talk about. Bradley wants you to know you did great work. And, well, Helen has a general question about how do you select a witness?
Okay, all right. So let's say we're not going to talk about the case. So we'll talk about trials generally.
Yeah.
And so I can give you guys, how you would run a case that you're running. The way that a case starts, and equality courts are a bit different. Equality courts are unusual in the sense that it's run by the Equality Act. They start on paper. So you basically have an affidavit that sets out what a case is about, and you sort of set out the nature of your complaint and what relief you'd like. The kinds of relief that can be given in equality courts are circumscribed by the Act. So, for example, a lot of people will probably want to know, in these kinds of hate speech cases that occur, why isn't there a criminal sanction? Because the Act doesn't allow it. So when we talk about people like Vicky Momberg or Penny Sparrow, there were criminal sanctions, but not through the equality court process. There were separate charges brought against them for criminal injuria. And so those are criminal, and that's why they led to criminal sanctions. But equality courts basically allow different kinds of relief. The one is that you can have a declaration about what has occurred. So in other words, whether the particular speech act itself was hate speech. something that you can ask for. You can ask for an apology. You can interdict that person from doing it again to reform their policies. And you can ask for the payment of damages, or you can ask, well, in addition, you can ask for money to be paid to an organization that combats racial hatred. And there is an element where the court can go and send the papers to the National Prosecuting Authority to investigate and see if there are any crimes. And so that's why you can have secondary cases that occur. Now, so you start off on paper, as I say, so you set out your case on an affidavit. Other side gets an opportunity to respond on affidavit as to what the issues are. Typically, these things are then case managed. So you go and sit down with a judge and you discuss what the issues are, how your matter is going to run. And then you sort of get a sense of, well, how much time do we have to run the matter? Who are the witnesses who would be important, to hear this case? Now, you don't always have to have witnesses. You can argue just off papers. So, for example, the flag case, which I was involved in, was run just on affidavits, largely a legal debate. So, we could sort of look at what the common cause facts were in that case, and then argue based on the law what the position ought to be. If we look at the John Quilani case, that in some ways is the model case for how to run a hate speech trial. I acted for John in the two appeal stages, so in the Supreme Court of Appeal and the Constitutional Court. And but I didn't act in the trial. But the trial, gives an indication of how you run these things. And what happened there was the Human Rights Commission had brought this complaint against John for hate speech. He'd written an article with the title "Call Me Names, but Gay is Not Okay," and there was an image of a man marrying a goat next to it. Now, John didn't author the title, didn't author the cartoon. The substance of his article was about whether we ought to have gay marriage in South Africa. And the article was written in about 2008, and gay marriage had been legalized in 2006. So it was quite an ongoing debate, and there'd been lots of discussion as to whether, the law requires gay marriage or not. And he took the view that we should change the Constitution insofar as it allows for a man to marry a man. And so he was part of how that case ran was that there was expert testimony around the nature of hate speech. And there were lay witnesses who talked about the effect of corrective rape in townships. And so there was a woman who testified saying that, as a black lesbian woman in townships, it's a particularly vulnerable situation to be in. And the court took that evidence very seriously, not just the trial court, but the appeal courts as well. And so that was something that played a role for me when I think about, when you're running equality court cases, how do you select your witnesses? You want to think what's pertinent, what gets the facts out, what are the facts that we need in this case? So do we need lay people who've been personally affected? Do we need experts who are able to give a sense of a wider context so that can be impressed upon a court? So those are the kinds of considerations one would take into account.
Yeah, let's talk a bit about hate speech itself. I think you mentioned it during the trial, how the law defines hate speech, and I think, for some people they would think, well, it's pretty cut and dry, but for those who may not know the actual definition, what is it?
It's been sort of subject to debate for a long time. So I'll give you a bit of a backstory. So our Constitution in Section 16 guarantees the right to freedom of expression, very broad general terms. So it includes artistic creativity, so not just artworks themselves, but the creative process, academic freedom, scientific inquiry, freedom of the press. And then it has these three exceptions. So it says these things are not included in the free speech right. So they're not explicitly prohibited by the Constitution. They just allow the legislature to introduce laws that would create sanctions for these things. And the three things are as follows. One is propaganda for war. Two, the incitement of imminent violence. And three, this is hate speech, advocacy of hatred on one of four grounds: race, gender, ethnicity, or religion, and that constitutes an incitement to cause harm. Now, that last bit, you'll see it's different in that it doesn't require imminency. So it doesn't mean that it's going to happen now. It doesn't require violence. It requires harm. But it talks about incitement. In other words, you're calling upon a group of people to go and visit harm on others. Now, the legislation which governs hate speech is in the Equality Act. And as I say, equality courts are governed by the Equality Act. But it also creates the sort of what I'd call a statutory delict because it doesn't create criminal sanctions. It creates the possibility of financial sanctions in the form of this hate speech prohibition. That's going to be in Section 10. And the difficulty with the way that was drafted was there was a lot of ambiguity as to what the test was. It referred to hurtful speech, for example. And so Penny Sparrow, for example, was held liable on the grounds that her speech was hurtful. And so the view was that hurtful speech equals hate speech. I then acted for John Krolani in a constitutional challenge to that legislation, and we were ultimately successful in the Supreme Court appeal and in the Constitutional Court. And the Constitutional Court held the act in its current form is unconstitutional, and it's created an interim test. And basically the way that that test works is similar to the Constitution, but slightly different. So first of all, I mentioned that there were 4 grounds: race, gender, ethnicity, and religion. The Act has about 17 grounds, and the court has for now allowed all those other grounds to stand. So that would include sexual orientation, it would include language, it includes belief, albinism, those sorts of things. Also, it says one of the things that must be present is that you're propagating or promoting hatred on one of those grounds. That has to be there for it to be hate speech. But then you can have one of the other two, which is that there's an incitement to harm, or that the words themselves are harmful. Now, that's different to hurtful. It's different to offensive. It's meant to be a higher threshold, and basically the view is that they would cause emotional or psychological harm of a deep and serious nature. So it's not just that you heard the words and you were upset momentarily. It's the kind of thing that would cause ongoing trauma were you to hear the words. So that's our current hate speech test.
That's very interesting because, so what you're saying is right now there's a test for hate speech. They wanted to, because I'm trying to do this in layman's terms, so they wanted to implement or start a law where hate speech was defined as some speech that hurts. But as you said, that's like a very broad definition. I mean, people these days get offended very easily, so it's also dangerous. But now there's like a test to see where the threshold is, so to speak. Am I getting that correctly?
Yes, that's right. So in other words, we've said that hurtful speech is sufficient to amount to hate speech. It can't be that it's merely offensive. It can't be that it causes the sort of mild temporary emotional distress. It must be serious. Yeah. It's still got to be tested in some ways. So there is another case that I was involved in called Masuku. The Constitutional Court just handed down judgment in that last week, Wednesday. And I acted for the Rule of Law project in that. And there what you have is the court using the Kolani test to hold Bongani Masuku liable for speech. And that gives indication of how it would be used to some extent on the incitement front. I think we'll find out in further case law how this sense of directly harmful speech operates.
Yeah.
The other thing that's worth clarifying, I think some people take the view that you have to prove that there is a causal link between the speech and an act of harm being incited in the world. In other words, someone says we should exterminate all the Armenians. We should gather together and we should round them up and we should exterminate them. Okay, and then there's an Armenian person who is killed. You don't have to prove that the speech led to the Armenian being killed. That's not the requirement in our law. That might be the requirement for, in other words, a different aspect of the law, like in the criminal realm. But the test here is it inciting? Is it calling upon people to perform the harm? And is there a reasonable likelihood that the harm will result? So that's, if let's say you said something like we should take all the Armenians and put them on a rocket and send them off to Mars, you might think, well, that would be harmful to be exported from the planet, but it's highly unlikely that would ever happen and therefore wouldn't meet that threshold. You know, you might think it meets the other threshold, which is that you're saying these people are so disgusting and despicable that they don't belong on planet Earth anymore. And maybe you can show that there's evidence that that's causing a harm to that group. In other words, people are heavily traumatized by that and feel marginalized and victimized. But it probably wouldn't meet your threshold on the incitement.
Interesting. Yeah, so it's not as cut and dry as people think. There's like almost like a science to it, if I can put it that way. Different things that you have to prove, different layers and different, almost creating that story, so to speak. I think one question I do want to ask you, and I do see other questions coming in, and I will get to them. So please, guys, keep your questions coming in. But I just wanted to ask you very quickly. You defined hate speech now according to our law as it stands at the moment. Would you stand on the side of, and I'm going to ask you a philosophical question now, because I know you're also a bit of a philosophy kind of guy. Do you think hate speech doesn't exist?
What do you mean it doesn't exist?
So I'm having an interesting debate in a few weeks with some guys about hate speech, and the one guest on my show about 2 weeks ago said that he doesn't believe that hate speech exists. The notion that, and he explained it like this: basically, we have freedom of speech, and freedom of speech should be, we should be allowed to say whatever it is we want to say. If they hold consequence, it's not, why should I be held accountable for something that someone else says? Or, sorry, something, why should I be held accountable if I say something and someone else acts on that? Like, that person has free will. They made a decision on their own to do something, whether it be like I said, okay, so I say, like, guys, as a joke, like, let's go rob a bank, okay? And then someone tomorrow goes and robs a bank. And then they say, yeah, but Joe Emilio on his show said go rob a bank. Like, I shouldn't be held accountable for that because that person had, that's like true free speech. That's how it should be, was the argument. And I was arguing like, well, no, there's real life consequences, and you can use that argument like, yeah, but that person has free will, but there's like limitations. Like, surely.
Yeah, I'll give you a couple of answers to it. The first is how we understand that intention requirement in South African law. So you made mention of, I meant it as a joke. Now our rule in South African law, based on the statute, is that your subjective intention is irrelevant. The question is, based on the context, how would a reasonable person understand the words? Okay, so that's sort of how we infer intent. Then there's questions about what's going on, say, metaphysically. In other words, is it ever possible to have speech? And there's questions as to, well, should we hold people accountable for speech? Now, there's a separate question as to, like, the law that you have. It's clearly the case that we have laws that describe certain speech acts as hate speech, and those laws are different around the world. So there's a separate question as to, well, ought we have any restrictions on speech? Now, there's something interesting, as you say, about the free will. Okay. And that's why I think we can hold two people accountable. So let's look at a simple case. I say to you, Joe, I'm going to give you 1,000 Rand if you go and kill a certain person. Okay. And I give you that instruction, and you obey the instruction and you kill them. Okay. Most legal systems around the world are going to hold you liable for killing that person. Okay. But they're also going to hold me liable. They're going to say, you issued the instruction. You had the intention for this person to die, and you used Joe as a tool in that. And so you exercise your free will in a manner that makes you morally accountable, and therefore why we want to hold you legally accountable. So that's our sort of assassin case. And I think they're going to be, we can just sort of build back from that, cases where we say, well, look, you could reasonably foresee that these people would act upon your words, and they must be held accountable for it. So, the classic case that John Stuart Mill has is you're standing in front of a mob, and the mob is very close to, I think in his example, it's a farmer, and he says, you say to the mob, the farmer is exploiting you, treating you badly. You're the workers who are being cheated by this guy. You should rise up and you should kill him. And they're so caught up in the fervor of this sort of the speech that they go out and they're right next to the farmhouse, and they go and burn the farmhouse down and they kill the farmer. Now, that mob should be held accountable for the killing, but you played a role in inciting that mob, and therefore you've also exercised your free will in a manner that makes you accountable. Mill thinks that once you start to step away from that, once you write that notion down in a book, for example, and it's read by individuals, it's less likely to be the kind of thing that causes harm in the world. It's diffuse. So you do get cases of people who go and blame texts for their killings. So you have these serial killers say, I watched this movie, or listened to the song, or read the book, and that might be way more diffuse, and that really they're trying to remove their accountability by blaming an external source. But I think that's quite different from the kind of live mob cases that I've discussed from Mo.
All right. So so what you're saying is we do have free speech, does exist, because we can say things. They just come with consequences depending on what it is you say.
Okay, so that's, I think, also to kind of make category errors. So I think to say you have free speech, like metaphysically, in other words, it is the case that you can say whatever you like, right? In other words, you have the ability to say whatever you like. Now, the question is, what would make it free? We don't just mean like the ability. We mean, in other words, that you will not be sanctioned. For it to be free speech, I think means speech that is not sanctioned by the state. Traditionally is how we've meant it. So in other words, you will not be arrested. A statute won't be invoked to hold you liable. In other words, when you say I'm free to say this, you don't just mean I have the ability to utter words from my mouth. You mean that I will not be held accountable. Now, we can talk about this vertical relationship, in other words, between going up in the state, and then we can talk horizontally as well. So, for example, if I say to you, Joe is a child molester, and a cheat and a liar and dishonest and all that sort of stuff, you might say, well, you're infringing upon my dignity rights. You're ruining my good reputation. These claims are all false and pernicious, and they're going to have real world consequences on me. So I am going to hold you accountable in defamation. You're going to sue me. And, if you're right and what I've said is not protected speech, then, I will be held liable and I'll be made to pay. So in that sense, I wasn't exercising a free speech right because it wasn't protected speech. In other words, it was defamatory speech without a defense. Now, the way our law of defamation works is that we have a couple of different defenses. So the one is it's true and for the public benefit. So it's not just true. So for example, let's say I said, Joe is a thief. I'm referring that when you're 2 years old, you once shoplifted some sweets from a candy store. You might think, well, it's not really in the public benefit for me to say this. It's an irrelevant detail. If you're Jacob Zuma and you've plundered, billions of rands from the state, then it is both true and in the public interest. The other one is it's a statement of comment, of an expression of opinion, not a statement of fact. So, and that the defense we call fair comment. But the case law says there's nothing fair about fair comment. It can be as bigoted or as extreme as you like. It just must be sincerely held, and that it's not making allegations. So if I called you a thief, that's an allegation of fact. If I said Joe has very poor taste in music, that seems to be an expression of an opinion. And let's assume that you're a DJ and your career is built on the fact that you play great music. It might very well have consequences for you. People might go, oh, geez, Joe really does have bad taste music. They're persuaded by my opinion. Still protected speech because it's an opinion. There are a couple of other kind of categories where we have these protected things. But yeah, in other words, it's the way that legal systems operate is that they're not as on-off as, you can say whatever you like or you can say nothing. There's nuance in it. And I think it's important to not trade on this ability to do things. In other words, utter words with your mouth. And then there's other kinds of consequences. Another sense in which, besides this horizontal case I've given, there are other kinds of sanctions. So, for example, you might say, I'm voting for Joe Biden in the next election. And when you say that, it's no government is going to hold you accountable. No one's going to sue you for it. But a bunch of people might be very disheartened to hear you say that. And they call for your cancellation on social media. Joe is a sellout and a traitor and, has poor taste in politics and we don't want to be your friend anymore, that sort of stuff, right? And so you might think there, your culture of free speech is being eroded. In other words, free speech is not just a matter of rights. It's about tolerating a diversity of views, and sort of stepping back from a cancel culture where we just go, I don't like what you said, so I'm going to take private mechanisms to ruin your life.
Yeah, no, absolutely. Cancel culture is horrible. But I mean, everybody, like you just said as well, everybody's entitled to have their own opinion. I guess it's just everybody's going to react differently to different opinions. I think one thing I'm trying to narrow it in now. Okay, so We've established it by law, but now I'll ask you again. With all that being said, hate speech. Do you think that's a thing? Because I'll explain it differently this time. An argument being made is that, well, I should be allowed to say whatever it is I want to say, even if it's going to hurt someone in a way of like being offensive or whatever. Or it's a hate speech is a limitation that like humans have made, and it's not real because everybody has a choice to be offended in a way. That's one of the arguments. I'm not advocating for this. I'm just trying to paraphrase what my
So first of
friend
all,
said.
I want to say, at least in the South African context, hate speech and offensive speech are very different things. Our case law is very clear that offensive speech is protected speech on that front. So we've got quite high thresholds for what you're entitled to say. Where the hate speech limitations kick in, really are these higher thresholds. In other words, it's not just making you momentarily sad; it's causing deep psychological trauma. So that's the one. Or you're calling on people to go and visit or harm upon others. That's the two. Now, of course, to say hate speech is just a man-made construct, yeah, obviously, right? All law is a man-made construct. Law is artifice. It doesn't exist in nature, right? So it's not like there's some sort of divine code that tells you this is what the law ought to be. But the same would apply with regards to a bunch of other prohibitions in the law. So you might say, well, I think I should be allowed to swing my knife all the way through someone's eyeball because that's what freedom requires. And we say as a society, well, actually, we think that our freedom should be mutually compatible with each other. And so you can swing your fist at the edge of my nose, but no further. And if you do it further, we're going to lock you up. And that would be a man-made artifice. The crime of murder is, constructed by men. There's a separate question as to what we ought to think the law should be. And different countries obviously take different views on free speech. The Americans tend to be the most legally permissive, but there are still restrictions on speech there. And other countries are incredibly restrictive of speech.
But what do you think about this comment? Hate is subjective and so are feelings.
So it depends what's being said. In other words, an emotional response appears to be the kind of thing that is felt internally, right? In the sense that it is subject dependent. I don't think you could, if you lived on an island on your own, it would not be possible to hurt anyone else's feelings, right? In the sense it requires another subject to interfere with.
Yeah.
There's another way in which subjective sort of means there is nothing objective about it. I would think with hatred, for example, as I said, the way we understand it in South African law is that we can objectively interpret words to determine whether they are in fact hateful. The case law in Canada, which we've imported, talks about, says hate is not a term of casual connotation. It describes extreme ill will or enmity. It's to marginalize, to victimize groups, to sort of say they are untermenschen, they are less than us, they are undeserving of rights and protections, they are visitors in our country, that sort of stuff. That all strikes me as quite objectively determinable. That's not just a matter of like, well, I guess it's just your opinion, man. Like, we can sort of look at a series of cases and, can kind of broadly agree that these things amount to hatred. There might be some category, vagueness. We'll always have vagueness. Might have heard of the sororities problem, which is I have a grain of sand and I put it on the one grain and then I keep adding a single grain. And at some juncture, it becomes a pile of sand. But you can't tell me when it becomes a pile of sand. It's vague. But we know the difference between a pile of sand and a grain of sand. They're not identical. So I think you're going to have similar things with regards to what amounts to hatred.
It's a valid point. This is all, look, I'm basically doing research for when that debate happens. It's not a debate, it's a discussion, but like, it's good information. It's good information because, like, I subscribe that there's hate speech exists. There's a reason why it's there. There's a reason why it's in law. I do think that some governments around the world take advantage of it, and I think that some governments around the world are not taking it seriously. I think that I've been subjected to hate speech for sure, and it's not fun. it does cause trauma. It can cause trauma, and some people have to take years to get over that trauma. We're at the end of the day emotional beings, and things we say do hold weight. So, but yeah, that's a discussion for another day. Okay, I'm going to get to some of the questions that were coming through. There's quite a few at the moment. This one was from Helen, who said or asked, is Mark on holiday now, or does he have a pile of other cases?
Yeah, I need to take a holiday. That's for damn sure. I do have a pile of other cases. I'm back in court on Wednesday for something else. I was in consults up until 6 today, I think. Yes, but if Helen wants to send me on a little holiday, I could deal with it. Yeah, the nature of advocacy is such that it's pretty damn busy.
Yeah.
But I intend on taking a break sometime in the future when I can.
Especially with you defending democracy and always being, I mean, yeah, you've told me some interesting stories in the past, and it's fascinating. Okay, this is a question from Matthew. So if I call a transgender person who tells me his pronouns, I'm not going to read that part. Am I liable to be charged and sent to jail if they call them?
Yes. Okay. So on this front, we have a common law rule called crimen injuria. Okay. Crimen injuria it's if you severely impact on someone's dignity, that amounts to a crime. And it could be done through physical actions or it could be done through words. So since the 80s, we've recognized that certain kinds of racial slurs amount to crimen injuria. You might think, for example, that if the reason why you're calling the trans person that is to denigrate them on the grounds of something quite important to them, and that it would have this dignity infringement situation, then you could well be punished for it. Now, Vicky Momberg was actually jailed for what she said. Before, generally, if you look at the case law, what you had was fines, and they were quite low amounts. So there is a sense in which, and that has been, Momberg's case was used as a precedent for someone else who was accused of using a racial slur. So yeah, if it's aimed at one particular individual on that basis, and the case was brought to explain why it amounts to severe impact infringement of dignity, it could very well lead to a criminal sanction, and that criminal sanction could be jail.
Well, there you go, Matthew.
That's an account of the law. It hasn't been tested yet in South Africa. And I think the trans debate, for example, is probably a little bit alien in SA as opposed to the UK and the States. I think if the question was phrased differently, in other words, if you engaged in a discussion with someone who said, I'd like you to refer me these particular pronouns, and you said, I will not be coerced into using those pronouns, or I don't think those are the correct pronouns. I think the pronouns I should use should track your biological status, not your gender status. That I don't think is going to amount to crimen injuria. I think that's going to be quite clearly protected speech.
Okay, that makes sense. Matthew, don't say those things. Just be on the side of safety here. I called a journo at the beginning of the show an idiot. Am I going to get in trouble for that?
Probably not. I mean, that sort of strikes me as the kind of thing that's within the realm. It also might be an expression of an opinion. So in other words,
very strong opinion.
The test for defamation is, would a right-thinking person think less of you having heard the words? And so obviously being referred to as an idiot, right thinkers would think less of you. Being an idiot is bad. But the question is, on opinion, was there some set of facts which made you say that? And you expressed an opinion to say, well, they said ABC, that's idiotic, therefore this person is an idiot. I would say protected speech.
Awesome. Fantastic. I'm safe.
I don't know why you call the person an idiot or what the background is, but
you're not on Twitter often, are you?
No.
So I
am in the sense that I was trending on Twitter.
I know.
but there's about four tweets under my name.
You should really like just even if you just like watch what goes down. Like you don't have to tweet anything. You could have just been like during the trial, like haha, I won. But no, there's a few journos on Twitter that are just yeah, they're being ridiculous. So
I cannot believe that South African journalists would be that way.
I know.
Joe, that just doesn't seem right.
Anyway, JC McFarlane asking, Mark, do you also do criminal work?
No, I don't.
Okay, simple answer there. And then Mork Rock Show, ladies and gentlemen, go subscribe, and also go subscribe to Mark's YouTube channel as well, Brain in Vat, something like that.
Brain in a vat.
Yes, that one. Is prosecuting people for a subjective feeling, namely hate speech, sorry that went away, not a very slippery slope? Why not just threat or violence?
Yeah, so I think it's to misconstrue what would be going on. First of all, it's not actually a prosecution in the sense that it's not criminal, it's civil. So that's mischaracterizing it. The subjective feeling, in other words, it could be, for example, the feeling that you're causing through the speech, we would reasonably expect to occur. In other words, it's not just that this person is sensitive and totally and utterly overreacted to what the speech was. There's got to be some objective fact of the matter that it caused this severe psychological or emotional harm. So yeah, on the slippery slope front, I do think we must be very, very careful about how we circumscribe speech. And so, when I acted for Kolani, I acted on the basis that we were arguing the law was unconstitutional and that it did create a slippery slope because it made nearly hurtful speech punishable. And we thought that was very dangerous. And, I think it's a victory for free speech that was set aside. And you definitely don't want a situation where someone can say, well, I personally have determined that speech amounts to hate speech, and that concludes the matter, and therefore you can't say it. That would, of course, be a slippery slope and would be very, very dangerous. It can't just be a matter where we say, however the target feels determines the matter. And we do talk about that socially. Someone says, well, I felt very hurt, therefore you shouldn't be allowed to say it. It's got to be more sophisticated than that.
Okay. And then Peter Sawanga, thank you, Peter, for joining and watching, asking, do you think that our hate speech laws are robust enough, or are they easily exploitable? Good question.
I suppose I'm not quite sure what he's getting at. In other words, robust enough implies that they could be stronger. There's quite a lot of hate speech sort of legislation floating around. There's the Hate Speech and Hate Crimes Bill, and the bills are not laws, they're kind of proto-laws. And there's been some very harsh sanctions mentioned in those. And so in the sense they're more robust, but they've also been much broader on the language and I think quite dangerous. And so I've written submissions on those bills. I think they would suppress speech. The current Equality Act, as I say, Constitutional Court has come up with an interim definition of hate speech. That's the one that operates now. It's a new test still could be formulated by Parliament within 2 years, and they may change it, but you've got to be within constitutional bounds. And so you can't just make it tougher because you feel like it. There's also the Cybercrimes Act, which has come into force, and I think that creates some quite severe criminal penalties for people who call on property destruction or on violent acts to be performed, and that may make certain people's lives more difficult, and they'll be held accountable. I'm not sure what he means by easily exploited.
Now, Peter, maybe you can elaborate on that a bit, Peter, if you're still watching, what you meant by exploited. I wonder if you can answer this question. I think so, because he's asking in general. How do you set a strategy for a case?
Yes. I think this is a really interesting question, and I have a multi-pronged practice. So, I deal with some of these high-profile public law constitutional cases, And then I also deal with, private commercial disputes, for example. We are, when you're designing strategy, you're doing it with the attorneys who are in the case. So as an advocate, I'm instructed by attorneys, and then there's a client behind that, and you've got to ask what it is that the client wants. Now, sometimes people say they want one thing, but actually want another. So, for example, in divorce cases, what you often see is that people are, it looks like they're asking for money, but actually what they're trying to do is punish their spouse. And then what they want to do is cause that person suffering. Or what they're trying to do is like a plea for help, and they want this marriage to survive, right? So understanding, well, what is it that you want is going to be pretty important for working out what the strategy should be to how to get there. Now, there are bounds in what you can do. So the tool that I have available to me as an advocate is the law, right? And you don't operate outside the law. So you must use the rules that are available to you. Sometimes you might think that the rule as it stands is an unconstitutional rule, and that your strategy is to have that rule set aside, and then you're relying on a high normal constitution. I think that's interesting is when you're not just dealing with private interests, but public interests. So your case will have an effect on public perceptions around a particular thing. So there's an advocacy role in the broader sense in that litigation. So you might want to get the message out about a certain value or issue, and it's important that you're able to express that. So depending on what those goals are, is going to define your strategy. My general rule is to work out what's the most efficient route towards victory for the client. I tend to want to be very short, sharp with my language, that I want to try and make it as crisp and clear as possible, that knowing your audiences, in most cases it's just the judge, means taking I've got the case I have on Wednesday is about 1,000 pages in it.
Sure.
So I want to be able to express that to the court in as simple a way as possible, to kind of, what we do often is I talked about writing heads of argument. That heads of argument are kind of like a roadmap for what the case is about, that someone can read that and they can understand what's there without having to read the 1,000 pages, but that if they want to, they know where to look in the 1,000 pages. So like heavily footnoted. So yeah, those are the kinds of things that I like to do.
How long does it take you to pile like a 1,000 page thing?
Depends on what's in the pages. There's different kinds of things you can have. So
Roughly,
for example, you might,
2 days, a week, a month.
I read pretty quickly, which helps. It depends on how dense it is. So as I say, like there's certain things that are quite common for me in some of the cases that I was running, like things that are like personal injury cases, where I could read 500 pages in an afternoon. And so that's sort of, you develop a skill to what to look for in those things. You have a familiarity with the kinds of expert reports that are in there. You're not passing every single word, because like this sort of stuff is pro forma. This thing is the thing I need to look for. These are the documents that matter most. But there's certain kinds of things where really you do have to read every word, and then it's going to take much, much longer to do it. Also, when I say the 1,000 pages, it's actually an underestimate, because that refers to the affidavits, or the annexures. It doesn't refer to all the cases.
Okay.
So, for example, in Tawane, there was 1,300 pages of docs, which a lot of it was trial transcripts. So, what evidence had been led in court, what the witnesses had said. But then there were probably another 500 pages worth of case law, that you had to read, and then, those cases often go and refer to lots of other cases, lots of principles. Those things are very dense. Reading 100 pages of a case is very different to reading 100 pages of testimony.
Yeah, no, absolutely. It sounds like you read a lot.
Yeah.
All right, so I got some more questions for you, but I want to get to what Peter actually elaborated on what he meant. So he says, I meant, are the laws so broad that they can be used to limit speech exploitable?
Yes. So in other words, I'm assuming what he means is unfairly limit speech. In other words, limit speech in a way that we think is unjustifiable.
Yeah.
And I think there's always that danger with any law that restricts speech. And as I say, I've spent a fair amount of time involved in lobbying efforts around like the hate speech bill and things like that, because I think that they were easily exploitable to punish people. I think the other thing that we've got to be worried about is that a law might look neutral on its face, but that only certain people are going to be punished with that law, especially in the criminal realm, where the only party that's bringing litigation is the state itself, it might be that it is used to punish its enemies or to punish certain political parties or people that don't hold a certain line. I think when you're thinking about a law, the drafters would think, how could this be used against us? What if the opposition were to come to power? Have we drafted this thing too broadly? Are we, as you say, censoring speech which ought to be protected? The other thing, for example, is to work out what are the kinds of speech that we currently tolerate. So in Kulani's case, for example, I said, let's have a reference point for a book that's widely available. And I picked up a copy of the Good News Bible, and I read from Leviticus and from Corinthians. And there's some quite bloodthirsty language that's used there in reference to homosexuals. And the fact is that the Bible is a very available book globally. We don't think it ought to be censored. People might not like the words that are in that text. It says it is an abomination for a man to have sex with another man, that those people deserve death, their blood shall be upon them. I certainly don't agree with any of that. I think it's quite despicable language, but clearly it's the kind of language we don't should be doing. It's in a book. And so, that's a useful reference point. In other words, when we're thinking about speech that we want to ban, we've got to say, well, what do we currently allow? What's the cost of this speech being around? You want to have a culture of tolerance to some extent.
Cool. Sorry, you cut out there. All right. So say that last part again.
I said it's important that when you're trying to work out what you want to tolerate in a society, one thing you might want to do is get a sense of those books or films or speech acts that we've generally allowed for a very long time. That's a good reason to say they should continue to be protected, and that your principled norms that are put in place must square with the reality.
Okay. All right. That makes sense to me. All right. So Helen asking, do you sleep?
Yeah, so I will put this, which is like I'm an incredibly busy, productive person. When I'm not working on a case, I'm running my weekly Brain in a Vat philosophy show. We, summon up an incredible mind from around the world once a week. And I have a pretty active social life as well. The things that I don't compromise on are I make sure I get 8 or 9 hours of sleep every day. I make sure I eat well. Like I spend time with people that I love. Like but I think why I'm pretty effective is that I'm largely anxiety free. I don't beat myself up at night. Have very few worries about things. I try to be very focused. I try to be very outcomes oriented in terms of getting things done. So I think that's what keeps me productive. I mean, during the pandemic, my co-host and I on Brain of That, so we've had almost 100 episodes, and we've produced 6 books as well. So we try and keep busy, and I've run, I don't know, on the day that I was cross-examining Julius, I had 2 judgments from the Constitutional Court handed down in my favor. I've been involved in a whole bunch of anti-lockdown litigation. Like, you kind of keep busy. And I think what helps as well is that the work's absolutely fascinating. It's rewarding. It's for the public good. Makes a big difference. I love what I do deeply.
Have you ever lost, okay, let me ask this, because let me ask it this way. Let me rephrase, Your Honor. What's your score? So have you won more than you've lost? If you can put it that way.
It depends how you count. There are certain cases that are probably neither wins nor losses, in that you reach an agreement with the other side. And so I suppose you can either count those as zeros, or you can count them as a win if your client is happy with the agreement. There are other cases that are heavily contested. In other words, then it's a win or a loss in that sense. I probably have I'd say an 80% win rate on those things. But having said that, if you speak to an advocate who says they've won all their cases, it's probably because they're not working on very complicated cases. The more difficult it gets, the more likely it is that you're going to wind up losing. And it might be that you lose initially but win later. And so, the question is how you do that count. In other words, if you lost in the High Court, lost in the FCA, and won in the Constitutional Court, is it 2 losses and a win, or is it one big win?
Well, I think the ones that you would count as 0 is a win, because I mean you didn't lose. It's not like a judgment, like I would count them as a win. That's what I'm trying to say.
Yeah. No, I'd say my win rate's pretty high. But look, when you lose, the losses are hard. You feel it. I ran a case for a client. I was on a set of facts that were very similar to one I'd won a few weeks before. We'd won quite decisively. Run the case, you figure it's a slam dunk, and we lost. And I was shocked. And we then won on appeal. And there's a really quite nice for the client to sort of, a lot of money was at stake. Made a difference to them. Sometimes you're going to lose, not because it's your fault, but depends on the day. I never guarantee wins to my clients because it's an uncertain system. You've still got a human being doing the adjudication.
Yeah, that's very true. Judges are humans too, right? With their own emotions and their own feelings and opinions. All right, so the Mork Rock Show asks, can Mark prove he has absolutely no relation to Jan van Riebeeck?
I have to say, for basically the last 38 years, there's a question that I get asked on a weekly basis, and it's, are you related to the Oppenheimer family? So I'm glad that I'm getting a varietal on that, which is, are you related to the Jan van Riebeeck? My answer to both questions is no. They're related to me.
They're related to you. And then he asks another question: are hippies a protected class? And can we generally hate on them? I think this is in relation to the Jimmy Carr incident.
Yeah, it is a question. I mean, on the protected class front, like, we've kind of expanded those classes up and up and up and up. So our constitution says these 4 classes. Interesting to think where hippies would fall on that. Whether it's like an ideological belief system or something, whether that's a protected class. Hating on its own is protected. It's the other stuff with the speech that you've got to do. It's not just propagating hatred against the group. It must also amount to those other 2 things. You can also privately hate whoever you like. In other words, if you just don't like long-haired men or whatever, and you think to yourself, geez, I really hate it whenever I have to watch that Captain Jesus van Riebeeck guy on Joe's show, go right ahead, man. You're free to hate. I don't think it's doing any good, but the law's not going to prohibit your internal hatred.
Yeah, no, absolutely. I think you're allowed to do a lot of things in your own private house as long as it doesn't, again, hurt or harm anyone. Are you allowed to talk about the flag situation, the flag case, or is that also ongoing?
I'll just say, I'll give an update as to where it is, which is that the case was heard by the High Court a number of years ago. My client brought an appeal. The appeal was stayed, waiting for the Polanyi judgment to come out. We have all the parties have now filed heads of arguments, and we await for a date from the Supreme Court of Appeal. So, in terms of a general update as to where the matter is, it's an alive matter.
And you're waiting for a date.
The effect, by the way, you're waiting for a date. The effect, by the way, of an appeal is to stay the judgment, which means that there's no prohibition on the flag as it stands.
And do you know if Afriforum is going to stream it like they did with the previous thing?
We don't know. It would depends on what the Supreme Court of Appeal will do regarding that.
They have to ask permission, right?
Yes. Yeah, it's not up to the parties, it's up to the court. The court may make a ruling on that.
Okay. All right. Well, we got a few minutes left, Mark. Is there anything you want to mention or say to anyone? Because, I know you can't talk about the case, right? I know. Unfortunately, you're limited by law. But is there anything you want to say about the memes? Is there anything you want to say about me? Because, you're almost famous now, man. You were trending on Twitter. That's an accomplishment.
Yes, I'll say a couple of things about this that I think is fair for me to say. The one is, I mean, some of the memes are very funny, and I think that's fine, and I don't mind all the unfunny big jokes, the Jesus jokes. That's fine. Uh, what I have found disturbing on online commentary is that there's been a kind of parallel world that goes on in terms of if people want to watch the case, the full case is available to watch. You can go onto ENCA's channel, you can go onto Afriforum's channel. SBC, I think, has quite a lot of it as well. And you can watch the entirety of those cases. What I find disturbing is the selectivity that some of the mainstream media has engaged in.
Yeah.
That seems to prevent a very different accounting. Um, and I find that disturbing. I think that also some of the meme war stuff is a bit of a distraction from a very serious matter. I'm quite a light-hearted person, and so I don't really take offense to that stuff. But I do think it's important that people, engage with the case, at least partly in the manner that it's a very, very serious matter. And yeah, I think the sort of that's something to bear in mind.
Yeah, it's exactly what I was talking about before you actually joined the show. Is I showed some clips from the trial. I mean, I think I said at the beginning of the show, I think that last day, you skip the beginning where the Julius's attorney is talking to the witness. That's just ego stroking. But when you start to cross-examine the witness, that's where it gets really interesting. And I was stuck to that TV, dude. Like, you have no idea. The way you cornered her and all that stuff. I mean, you've seen the clips that I put out there. And I showed some more clips that I didn't show on social media during the show, showing how you were chipping away at the ideologies and stuff like that and cornering her and saying, like, well, you can say that it's two interpretations, but not now. You're saying it's not hypothetical, all that cock. The point I'm getting at is I also said it is worth watching that even if you just watch that last day, it's worth it. That one and Julius testifying, because I think that the entire trial is 9 days, if I'm not mistaken.
Yes, I understand why you've said that, and I think those days are interesting days, partly to watch because I'm the cross-examiner, in the sense that there's a combativeness to it and there's entertainment value to it. I will say that the heart of our case really is in what we brought ourselves, which is
Yes.
in the first 6 days. And I think that's something that it's wonderful that we're in a situation where there's a public record that can track that. And I think that it's very valuable for people to be able to watch that material to get a sense of what happened during the case. It's and it is. I found it. I found the case an absolutely riveting experience. I think it's one of those cases. My opponent and I take a view that you should be as collegial as possible with your opponents. That we act on the instructions of our clients. That you don't hold the legal representatives liable for things their clients do. Try and conduct the thing in a way that's civil. And I said to him, "This is a once in a decade experience. That we'll both look back on. Like these things are very, very rare."
Yeah.
And it's an amazing thing for the public to be able to watch it and get a sense of how litigation works. I do think lots of Twitter lawyers, lots of people sort of saying, "Oh, you've done a terrible job on this or that or whatever." Like it helps if you understand how litigation works, what you're entitled to do at different stages. Understanding a broad strategy that sort of gives you put in a situation where you can actually evaluate. But I've received a number of mails from colleagues saying, they really enjoyed a certain moment in it, or a certain technique that was used. And so it's an amazing thing for people that I've got friends who are at the moment training to become advocates, for them to have a record that they can look at and diagnose down the line and go, that was a really useful way of leading a witness or of trying to get a result out in cross-examination, or this thing didn't work very well, I wonder how it could have been done differently.
Yes.
That's an amazing situation to be in as a lawyer, to be able to look at it, because there aren't many trials that are publicly available.
Yes. Now, I think there should be a movie made out of this, man. Like, it's that interesting to watch it all go down, because it's not like the movies itself. Like, obviously, you could dramatize it a little bit more in the movies, but it's like one of the few court cases that you're actually like, I can watch this. It's long, but you can watch it. I just want to get to
Yeah.
some of
I mean, I
the.
will say that it doesn't look long if you look at a video stream, but you can also, there's an hour lunch break in there, there's tea
Yes.
breaks, there's procedural, finagling.
Yeah.
So it is quite watchable in the sense that you can scrub past the bits that are, not of interest to a particular viewer, but there's some amazing material. I think there's probably a really, really good 2 hour docu that could be made out of it, that just has court material and that sort of, covers all the salient parts of the evidence.
Sure, that's going to take a while to compilate that because, like, I think the first 3 days are like 6 hours long. Like, they're long. But let me.
I'll be doing some of that when I write my heads of argument.
All right. So, Mork again asking, have you gotten any threats from an unnamed political party? I also want to know.
Look, as I say, I don't really spend much time on Twitter, so it's entirely possible. Yeah.
Okay, in your emails. No.
No, I've got no threatening emails. I've gotten quite a lot of private correspondence that's been very positive.
Okay.
But no threats. Yeah.
All right, that's good. That is good. And then final question for the evening. Sorry, guys, I'm gonna have to call this one.
We did get threats in the proceedings.
Yes.
We traveled to court with bodyguards. The court was invaded by protesters. We were blockaded and exiting. So I don't want to make light of it in the sense that it's pretty damn serious.
Yeah.
Yeah.
We
got a threat at the start of the litigation, and Lozi put out a tweet saying that the translation is shoot. These dogs are cowards. Shoot.
Oh wow.
And so that was the start of our litigation. So in that sense,
these guys just don't learn. Ever lost your cool in a case? Juju tried hard. I will say, from what I saw in the last day, I wouldn't say you lost your cool, but you got stern because you were tired of her cock. But yeah, I wouldn't say you shouted or anything like that. You just got stern, like cut the bullshit, answer the question, which was nice to see, because yeah. But yeah, besides this case, have you ever lost your cool in any other cases?
Not that I can think of. Not in the litigation, like not in court. I've definitely had moments afterwards where you lose your cool. But I'm generally, a very calm, collected person. It takes a lot for me to raise my voice. I think very few people have ever seen me angry. I have the capacity for it, but yeah, very rare thing to see.
I've got to say, someone commented earlier on in the comments. I can't see it now, but they said you have a lot of patience, and I've got to agree, man. Like I'm, when I was watching you on day 9, I'm like shouting at the TV, like, and you're just so calm. Which is great.
Yes, you got to pay two senses, and the one is a temperament sense. So like your demeanor is patient and calm. The other one is that cross-examination is partly a fishing game. You are putting out a line. You're trying to see if this thing works. You have to be patient to try and get the details. And I think some people, when watching cross-examination, might get frustrated. They think, "Where's this going? What's happening here?" It's because you have to be patient to kind of get the thing that you want.
Yeah. Absolutely. The fish analogy is great.
This Masuku case, which just got handed down, that took 13 years for finality. It took 13 years for the Jewish community, to get an award against Bongani Masuku for anti-Semitic hate speech. That requires an enormous amount of patience from the community side, in other words, from the Zionist Fed side, from the lawyers who've been running it. These things take an enormous amount of time. So I think because litigation generally grinds slowly, you develop a patient streak. You have to.
Yeah, shit, man. 13 years is a very long time. You like in some way your cases can be like a teenager, like, you know what I mean, like, or an adult. Jeez, okay. Insane, man, insane. Look, we got to cut it off here. I have to go, but I just want to say, Mark, thank you so much for joining me on the show. I know that we were going to talk about something else, but obviously with what happened the past week, I thought, hey, let's talk about this topic again, hate speech, and anything you can tell the public about the case or anything around the case would be great. But sincerely from me, look, I I would definitely want to say this to you. I know that you and I were chatting on WhatsApp a few times last week, but I do want to say this publicly and to you. Thank you for your amazing work that you did, and do not let the negativity get to you. I know you don't, but I think anybody who, especially on day 8, who didn't appreciate what you did, then they're too short-sighted to see what a great advocate you actually are. And you're going to be famous one day, man, and just don't forget about us.
Thanks, man. Much appreciated.
All right, buddy. You can hang up. It was a pleasure hanging out with you. And once again, plug yourself, man. Where can people find you?
Yeah, so if you're interested in the philosophy stuff, check out Brain Navat. We've got a channel. If you're interested in some of the other litigation that I do, there's a Mark Oppenheimer channel. It's got about 100 videos. It's a collection of interviews. I think the flag case is up there. There's some other Concord cases that I've done. There's a case we didn't talk about at all. There's a big win around BEE. We declared the minister's regulations around procurement unconstitutional, and a 5-4 decision.
Nice.
The court very much relied on the arguments I'd made for my clients, so I found that just an incredible victory. Also, one that's gone on for many years since 2017.
Awesome.
And so you can watch that on my YouTube channel as well.
All right, ladies and gentlemen, go check out Mark Oppenheimer. Mark, thanks again for joining me, buddy. I'll have you again soon.
Excellent. Ciao.
Ciao. All right, ladies and gentlemen.